India development debate, and of course the focus continues to be the Rafale dogfight. Now, former BJP leaders Arun Shourie and Yashwant Sinha, along with lawyer Prashant Bhushan, today have filed a review petition in the Supreme Court challenging its judgment refusing a CBI inquiry into the Rafale defence deal between India and France. We've got Mr. Prashant Bhushan, who's joining in right here on the show to quickly take us through what the main plea really here is. Mr. Prashant Bhushan, good evening, and thank you so much for taking the time out. You filed a review petition before the Supreme Court in wake, of course, of the 14 December judgment that didn't find any procedural lapses in the deal. We know for a fact that the final judgment has nothing to do with these lapses. What makes you so hopeful that the court's going to take a different view now?
No, it's not a question of our being hopeful or not. The point is that the judgment is full of so many gross errors. Firstly, it doesn't address the prayer that we had made, which was for an investigation. It proceeds on the basis as if we were asking for cancellation of the contract. Secondly, it relies on an unsigned note handed by the government to the court in a sealed cover, and treats those facts as gospel truth when firstly that sealed cover wasn't shared with us, so it's a gross violation of natural justice for the court to rely on some facts which are firstly not even on affidavit, they are not even evidence as far as court procedures go, and which are not shared with the petitioner, and which are found to be false. So many facts which the court has noted from the sealed cover are found to be false. About the CAG, non-existent CAG report, about this Mukesh Ambani company being a parent of the Anil Ambani company, about what the Air Force officers came and told the court in open court. I mean, so many facts are false. And not only that, they have not even referred to the refutation of conclusive refutation of those facts or so-called facts by us with reference to documentary evidence. That is not even referred to by the court.
Right. Sir, let me ask you very honestly, you know, we know that you're pleading for a CBI inquiry, but considering its poor track record in probing defense deals, what's giving you the confidence that a caged parrot like the CBI can actually bring the truth out?
No, that's why we had asked for a court-monitored inquiry. Once the court monitors it, then the court can appoint an SIT within the CBI and can get regular reports from them and see whether they are proceeding at all or proceeding in the right direction or not. So that's why court monitoring was important.
Okay. Now, the Supreme Court has also, you know, sort of erroneously said in its verdict that the government had submitted pricing details to the CAG and the auditor's report has been scrutinized by the PAC. Do you think that there was a deliberate attempt by the centre to mislead the court?
Yes, it appears so. There were not just in this matter, but also about that conflating that Mukesh Ambani company with the Anil Ambani company, etc. So there are several things on which the secondly the government told the court that there was as if there was consensus in the price negotiating committee, when we now know that 3 of the officers who were the experts on price, etc., had raised very serious objections about increasing the benchmark price from 5.2 billion to 8.2 billion. And yet that increase of that benchmark price was approved eventually by the Cabinet Committee on Security headed by Mr. Modi himself. All these facts were concealed from the court. So many facts were concealed from the court. These 3 members had raised 10 objections which Caravan has published about the French government not giving a guarantee and therefore this is not a government to government deal, about even Dassault not giving a guarantee, about Dassault not likely to adhere to its delivery schedule in these aircraft. So many objections had been raised.
Okay.
But all those objections were overlooked and overruled finally by the Mr. Modi himself.
Right. Mr. Bhushan, the pricing detail was not shared with petitioners. Now, you've asked for an oral hearing of the petition in an open court. Would you be requesting the court to make the pricing details public? Because, you know, the government has time and again said that it's bound by a secrecy clause.
Well, we had pointed out that that secrecy clause doesn't apply to all this.
Okay.
It only applies to very sensitive security information. Price the government had disclosed formally in Parliament also. So how can the government claim secrecy about the price? That is absurd. So therefore, we will ask for that, but even in the absence of that, how can the court rely? It's completely unknown to law for the court to rely on some unsigned note which is not even an affidavit, not signed, and which facts are found to be false. I mean, I can't imagine the kind of embarrassment that the court has suffered in this case because of relying on this unsigned note handed over to it in a sealed cover.
Right. My last question, sir. The Supreme Court has said that it cannot dictate the terms of the deal to the government, although the petitioners never asked for it. Do you think the court erred by taking a sort of 360-degree view to give the government a clean chit?
Yes, I mean, the court's judgment is quite contradictory. On one hand, it says that it is not the domain of the court to go into all this. On the other hand, the judgment says that no, but we looked into the matter, we find nothing grossly wrong with it, and we feel that the procedure adopted is basically okay, etc., etc. I mean, I don't understand. First, they entertained two petitions which are, according to the court itself, bogus petitions. First petition by M.L. Sharma, court said this grossly inadequate. Second petition by that Dhanda in his petition claimed that I have filed this petition to clear the name of the Prime Minister. So, court entertains these two bogus petitions, then asks the government to file something in a sealed cover, then asks the government to file something more in a sealed cover, then those sealed covers are not even signed, takes cognizance, relies upon the claims made in those unsigned notes handed over in a sealed cover, etc., and passes a judgment without even considering our conclusive refutations of those claims. I mean, what kind of court procedure is this?